All right, this is Judge Krier again. It's 8:29, so I think we can get started. The first case I have on my docket is Webb Roofing versus Castle Key, 20 CA 3981. Is there anybody here for the plaintiff?
Good morning, Judge. Steve Carestes for the plaintiff.
Hey, Mr. Carestes, I noticed this is a motion to withdraw, but I did not see a notice of hearing in the file. So unless I missed it, which if perhaps you could direct me to the filing date, you just need to reset this.
Okay.
Or get a consent from your client.
I unfortunately can't do that. It looks like it may have just, it looks like the notice is incorrect anyway.
Oh, there's a notice in the file, but it's for something else.
Yeah, there's a notice that was filed yesterday for today, but it looks like the certificate of service is incorrect anyway.
Well, that wouldn't be enough notice, would it? So.
No.
Anyways, okay, just reset it, okay?
Yes, ma'am.
All right, thank you. All right, next case is Russell versus First Protective, 20 CA 605. Who's here for the plaintiff? Anybody?
Your Honor, is it Regenthal? Russell and Regenthal?
I have Mr. Parsons.
Yes. It's,
you're right, it's Regenthal
yes,
versus
Your Honor,
First Protective.
All yes, right, this is Mr. Parsons for the plaintiff.
All right, who's here for the defendant?
Eric Ressman on behalf of the defendant, Your Honor.
All right, so this is plaintiff's motion for an order to show cause, to compel, to strike, et cetera, et cetera, et cetera. So go ahead, Mr. Parsons.
Yes, thank you, Your Honor. So defendant's expert discovery responses were due on March 21st. Plaintiff filed a motion to compel those responses on April 30th. An agreed order was entered that gave the defendant, or an agreed order was entered that provided that the defendant provide those responses on May 7th. On May 8th, the defendant filed unverified responses to the expert ROGs and responses to expert requests to produce. In their responses, instead of actually answering the ROGs, they opted to produce documents, which is fine by our standards, but they did not produce any documents in those responses, even though it was filed a day late. The plaintiff was set to take the deposition of defendant's expert on May 11th. It was only after the plaintiff, or it was only after my office followed up with those document requests prior to the deposition that the documents were produced only an hour before the deposition, and we believe they were incomplete. The defendant didn't timely comply with the agreed order. The plaintiff's expert, which was set to be deposed the next day, was not afforded enough time to review the documents because of this conduct. And the plaintiff was unable to be on notice of the opinions of the defendant's experts and have a full and fair opportunity to prepare and confront the opinions of the defendant's expert due to this conduct. So we ask that the court strike Mr. Hernandez as an expert witness, order the defendant to show cause for failing to comply with the order, and in the alternative, compel better responses to the request to produce.
All right,
for sanctions,
Your Honor.
Excuse me.
Your Honor, what occurred was we did provide the documents prior to the deposition of Mr. Hernandez.
An hour before.
Yes, Your Honor. And
how is it that you think that that's sufficient? And also, unverified responses to expert interrogatories. I mean, none of this complies with the rules of procedure. So I'm just sort of curious as to what the reason is for that.
Well, Judge, it was an error in my office. However, there is not the prejudice that's been alleged. Mr. Hernandez's depot has not been concluded. The plaintiff's expert can certainly review the expert discovery as well as Mr. Hernandez's depot. We also received documents late just before the...
Okay, but your motion's not in front of the court. When your motion's in front of the court, I'll deal with that.
Yes, Judge. So what I plaintiff to strike Mr. Hernandez as an expert witness, they would have to show prejudice, Your Honor. They haven't shown prejudice. They have a deposition that they took for 5.5 hours of Mr. Hernandez. They didn't conclude it. They can certainly go through the discovery that was given to them late, and they can ask him more questions concerning that discovery. We believe that the discovery given was complete, that there's no prejudice. They have not presented to Your Honor the deposition of Mr. Hernandez. They've not articulated any prejudice going into the trial in August. Your Honor, I think that the sanction of striking Mr. Hernandez is extreme and is not called for in this case, Your Honor.
All right. Well, here's what I'm going to do. First of all, we have rules of civil procedure, and I expect them to be followed.
Yes,
So
sir.
number one, producing documents in response to expert interrogatories is not sufficient. So number two, saying you're going to produce documents and then not producing them is not sufficient. And number three, doing expert interrogatories that are not even verified is not sufficient. So, and then doing this, all of this, producing some documents right before a deposition is prejudicial. So number one, I'm not going to strike the expert, but I am going to award fees, 57-105 fees, not discovery fees, for the cost of this motion and hearing, for the fees expended by the plaintiff in connection with the deposition. I'm going to require that you comply with the rules of civil procedure and the previous court orders within 10 days of today's date. And the deposition of the expert can be taken over again, completely over again. And you're responsible for the expert's fees for the past deposition as well as this deposition, the new deposition. I'm also going to continue your trial until September, because none of you guys are going to be ready. Your pretrial for the August trial period is, let's see, June 28th. You're not ready. So I'm going to have a new trial order issued for September, and you all should be ready by then. So, Mr. Parsons, I'd like an order to that effect sent to my office email address in Word format after you've circulated it to Mr. Gressman.
Okay, sorry, Your Honor. Yeah, you listed quite a few things. I was trying to take them down while you were going. So you're not striking Mr. Hernandez, but you're awarding fees pursuant to statute 57-105 for today's hearing.
Which means that Mr. Gressman or his firm is going to be responsible for 1/2 of those fees.
Yes, and the deposition, the first deposition for Mr. Hernandez, they need to comply with the agreed order within 10 days. Trial continued to September. And was there anything else?
That you can take the deposition of the expert over completely. Meaning you can ask the same questions if you want to ask them.
Okay, and and I believe you also said that they're responsible for the expert fees of Joe Hernandez for both deposition?
Correct. All right, thank you, gentlemen.
Oh, one more thing, Your Honor. I saw that, I understood that you continued the trial to September. Will you be issuing another order?
Yes.
And
I'll be issuing an order.
And on that note, Your Honor, we've been trying to coordinate the continued deposition of the defendant's engineer. We've sent a couple requests for additional dates.
I don't have that motion in front of me, Mr. Parsons.
Understood.
So if you need another motion, get it filed and set it in front of me.
Understood, Your Honor. Thank you.
All right, but I think you guys can tell that I don't have. I believe in complying with the rules of procedure and also any orders of court. So govern yourselves accordingly.
Thank you, Your Honor.
All right, thank you, gentlemen.
Thank you, Judge.
All right, next case is Blocker 20 CP 2083. Who's here for the personal representative?
Good morning, Your Honor. This is Kenny Kemp. Nice to see you.
You too. Anybody here for anybody else?
Good morning, Judge. Sean O'Connor, and also present is Morgan Cronin as counsel for the surviving spouse, Lena Blocker.
Okay. You guys have scheduled this for 10 minutes. Is that going to be sufficient time?
I think so, Your Honor.
Okay. Go ahead.
All right, thanks, Judge. Mr. Blocker and Lena Blocker were married back in 2011. Prior to their marriage, they entered into a marital prenuptial agreement dated 2011. The decedent died unexpectedly at 44 years old last year in August of 2020. Back in December 10th of 2020, Ms. Blocker filed a claim in the estate for intestate rights, which has been filed in a file, and I provided it to Your Honor prior to today's hearing. In looking at the claim, Ms. Lena Blocker asserts intestate rights right in the first line for exempt property, the intestate share of the decedent's estate, family allowance, elective share, and homestead rights. And when you look at Florida statute 732.201, that statute tells you what a claim is. It tells you a claim is a liability of the decedent arising in contract, tort, or otherwise prior to the decedent's death. The second sentence in that particular statute says that the term does not include an expense of administration or estate, inheritance, or succession or other death taxes. So what Ms. Blocker filed is a claim that contains inheritance rights. They're statutory rights. It's exactly what the statute says you cannot file a claim for. So we filed a motion to strike her claim, and that's the basis of our motion.
All right, who's responding to this?
Morning, Judge. Sean O'Connor again on behalf of Lena Blocker.
Okay.
I am inclined to agree with counsel that as presented, the statement of claim does not reference the parties' premarital agreement. However, the court, pursuant to Florida Probate Rule 5.490D, states if a claim as filed is sufficient to notify interested persons of its substance, but is otherwise defective as to form, the court may permit the claim to be amended at any time. And it's our position that given the response of the state council, that and given the equities of the case, that is to determine ultimately whether there is a valid prenuptial agreement, whether there was fraudulent concealment, fraudulent misrepresentations, that Ms. Blocker should be allowed to amend her statement of claim in order to assert her contract, tort, or as Mr. Kemp stated in statute 731.2014, contract, tort, or otherwise, which would, at least to us, include an action for declaratory relief to determine the validity of the prenup, as well as possible contract and tort claims, that she should be allowed to amend her statement of claim. Otherwise, this would essentially operate as a technical disposition of the case and not a determination of the case upon the merits, as is Florida's longstanding public policy.
Right, Mr. Kemp?
Yes, Your Honor. Well, when you look at the statement of claim, you can amend a claim for procedure, and that's right in the rule, but you can amend a complaint or the claim for substantive. And what is in paragraph 1 is the substance of their claim, which is inheritance rights, which is prohibited by the statute. So they can't amend on substance. They can certainly amend on procedure, and there's nothing wrong procedurally with their claim. It's the substance of the claim.
All right. No, that's not how I conduct hearing. This is not an ongoing discussion. All right, I'm granting the motion to strike. Mr. Kemp, I'd like an order from you after you've circulated it, forwarded my office email address in Word format. No leave to amend.
Thank you, Judge.
Thank you.
Thank you, Judge.
All right, next case is Roofing Reconstruction versus Homeowner's Choice, 19 CA 4192. Who's here for the plaintiff?
Good morning, Your Honor. Dayron Montez Dioka for the plaintiff.
Okay, and who's here for defendant?
Good morning, Matthew Watkins, Your Honor.
All right, so this is plaintiff's motion for trial continuance because somebody's on maternity leave. It doesn't look like either one of you are.
Well, it's actually paternity leave, Your Honor. At the beginning of the trial docket, my first child's going to be born. She's due August 14th, and I believe she's coming early. So I believe this trial docket begins on August 4th. So
Okay.
I recently took this case over. The prior attorney is no longer with my firm, so I'll be taking lead going forward.
Okay,
Go ahead. I'm sorry.
I will. The Supreme Court has told us that we need to give deference to maternity and paternity leave. So, I don't think that there's a lot of choice, despite the fact that I never took that much time off, but nevertheless. Yeah, so when do you want it rescheduled to?
Judge, I will be back in the office October 1st. So anytime, I think the last quarter of 2021, we can go to trial if Mr. Watkins agrees.
All right. I have a docket that starts October 20th and one that starts November 17th.
I would request October, Your Honor.
Okay, will that work for you, Mr. Montez?
Yes, it will.
Okay, so I'll set you guys for the October 20th trial docket. The pretrial is September 9th. You're gonna be able to check in. All my pretrials are gonna be via Zoom, so.
Yep, that won't be a problem, Your Honor.
Okay.
I'll check in for that.
Okay, so I'll have a new order issued for that trial docket. And good luck. This is your first baby?
It is, Judge.
All right, well, good luck.
Thank you so much.
Yep, take care. Oh, I'm gonna need an order. I'm gonna need an order from you with regard to this hearing. You can just say that the motion's granted and the court's gonna be reissuing a new trial order.
Understood. We'll send one over today.
All right, thanks very much. To my office email address in Word format.
Thank you, Your Honor.
All right, next case is Durrett versus First Protective, 21 CA 136. Who's here for the plaintiff?
Good morning, Judge. My name is Erin Donovan, representing Kathy and Alva Direct.
Okay, and who's here for defendant?
Good morning, Your Honor. Ryan Marks on behalf of defendant.
All right,
and there's a court reporter. I'm sorry, there's a court reporter present.
All right, thank you. This is a defendant's motion to dismiss, so go ahead, Mr. Marks.
Great, thanks, Your Honor. Defendant's motion to dismiss the second complaint. The complaint consists of 2 counts.
This is just for count 2, correct? This is just count 2.
Both. I think both counts, Your Honor.
Really? Okay.
No,
what do you mean
count
you
2.
think both counts?
So it's just count 2, Your Honor.
That's what I thought. Okay, go ahead.
Yes. Due to the fact that the DEC action is duplicative of the breach of contract action, in count asking to determine whether there was coverage for the loss, attached to the complaint, Exhibit C is a letter to the insured stating that the coverage for the loss was accepted, but denied in part. Coverage for the roof was denied based on an excluded cause, but for the into the home was accepted. This is all part of one claim of loss. Coverage was accepted based on the attached exhibit to the complaint. There's no doubt here. Well, the plaintiff in their response says that they're in doubt as to their duties after the loss, specifically whether an EUO can be required by the insurer because they contend that the claim was denied. But according to the exhibit, the claim wasn't denied. And as the claim wasn't denied, there is coverage for at least part of the loss, and therefore the EUO is
in addition to the fact that there's no need for a DEC action when you've sued on breach of contract. So, Ms. Donovan, what is your position here?
Well, we don't believe the counts are duplicative, and we filed both counts to protect our client because the way that we view the count for breach of contract is this is a full denial. Now, it is a constructive denial because technically they admitted that there might be covered damages to the interior only. However, because those damages fell below the deductible, that they've, constructively denied the claim. And so we believe the breach of contract is appropriate. The reason that we filed the declaratory judgment action is in January, we got a request for an examination under oath for the first time after, over a year of Frontline basically telling us they weren't going to pay us any benefits on the claim. So we wanted to make sure that we were protecting our client from, under the case law, the line of case law that provides that once an insurance company denies the claim, that further de-obligates plaintiff or the insured from complying with any further policy conditions or cooperation clauses such as the EUO. And so we were filing the DEC action to just protect our client should defendant, argue that, the matter needs to be dismissed or stayed because of not having done the EUO. And we don't believe that asking for the EUO was appropriate, given the fact that this was a denied claim in the first place. So that is the reason. So we do not believe the counts are duplicative. If I'm looking at this from a 30-foot view, this is a breach of contract case. However, because we had that quirky EUO request after Frontline had stuck with their denial of the claim for over a year, we wanted to protect our client's rights by filing the declaratory judgment action. And because we don't believe they're duplicative, we would ask that both actions lie. And, if something needs to be dismissed with at the summary judgment stage, so be it. But we don't believe it's appropriate to dismiss either count at this time, Your Honor.
All right. Well, I am going to dismiss count 2 with prejudice. I'll need an order from you, Mr. Marks. Sent to my office email address in Word format after you've circulated it to opposing counsel.
Okay, and then we just proceed on the breach of contract count 1 then, Your Honor.
Yep, that's what 1,000 IRMA cases that I have in front of me have been doing.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
All right, next case is CRF Building 600 Limited Partnership versus American Seas Trading, LLC, 20 CA 2267. Who's here for the plaintiff?
Good morning, Your Honor. My name is Amanda Globetti from Coleman Hazard, and I am here for the plaintiff, CRF Building.
All right.
600.
Okay, and who's here for defendant? I have a Mr. Rieger.
Yes, ma'am.
Mr. Rieger, are you present? I have not seen your name anywhere. This is a motion. This is your motion for contempt and also a motion to compel request for production.
Yes, Your Honor.
With regard to, this is a post-judgment discovery. So this is just with regard to the fact information sheet and also compelling discovery post-judgment, correct?
Yes, Your Honor.
Okay, so your motions are granted. They've got 20 days from today.
Yes, Your Honor.
And you may want to include some language in there that if they do not comply, that the court can issue a writ of bodily attachment and they can be attached and taken to jail.
Thank you, Your Honor.
All right, thank you.
Have a good day.
You too. Last case on the 8:30 docket is CADA 16 CP 1549.
Good morning, Your Honor. Jeff Jones on behalf of defendant Andrew Cada.
And Jeff Fritkin here, Your Honor.
Jim Moon on behalf of Lori Cada.
Everybody slow down a minute here. Okay, so Mr. Fritkin's here representing the PR. I'm sorry, what's your name again? From Jack Harris?
Oh, I'm sorry, Your Honor. Jeff Jones.
Okay, Mr. Jones is here representing Andrew Cada. Anybody else here representing anybody else?
James Moon on behalf of Lori Cada, Your Honor.
Okay. And I've got a few people present. Okay. And who's Christian? Anybody know who that is?
I don't, Your Honor.
Whoever's designated as Christian, is that a court reporter or who are you?
Sorry, Your Honor, this is Gilberto awaiting our case to come up.
Well, this is the last case on my docket, so I don't know what case you're waiting to have me hear.
Docket number 12.
That doesn't help me.
Case number 2021 CA 946.
I was informed that was canceled.
Oh. Canceled?
Yeah, we didn't cancel it.
Okay.
Or continue. But I mean, if you want it heard, I mean, I think somebody filed a motion for continuance. That's why I assumed that it was canceled. You want to go? I think, did you file the motion for continuance?
No, we didn't file anything. We were just trying to see what was going on with that.
All right.
This is news to me.
People in CADA, give me a minute. Let me just deal with this because this is going to be shorter than yours. Let's see.
Says it was canceled per attorney.
Yeah, that's what I have in my file too. So.
She canceled with her attorney?
I don't know which attorney.
Oh, but she did cancel.
We don't cancel it unless the attorney setting the hearing cancels it.
Okay.
So
okay.
Was that you?
No, that wasn't us that canceled it.
Okay. But are you the movant on the motion for summary judgment?
Yes.
Okay. Well, then I don't know how it got canceled because yeah, but that's what my my docket reflects, is that it was canceled. So if you want it set, reset it. I'll be happy to hear it. But since there seems to be some discrepancy and it doesn't look like the other side is here, I think we should probably reset it. All right.
Okay.
All right. Thanks very much.
Thank you.
All right. Going back to CADA. This is Andrew CADA's motion to dismiss the petitioner's amended petition for surcharge. So go ahead, Mr. Jones.
Thank you, Your Honor. Your Honor, this is a amended petition for surcharge. Count one, seeking allegedly improper attorney's fees paid by Mr. CADA while administrator ad litem, and count two, seeking excessive compensation paid to Mr. CADA while president and CEO of International Controls and Measurements Corporation in Syracuse. The court reviewing that would think, well, that would be appropriately acceptable as a surcharge action. Unfortunately, it's the manner in which the parties are alleged to have various interests that creates the problem. And I acknowledge that Mr. Friedkin did attempt and did in fact amend, but we believe there's still deficiencies, Your Honor. In each count, there is an allegation that these three parties, the personal representative, International Controls and Measurements Corp, and ICM Controls Corp are seeking various remedies. If the court may recall, ICM, or International Controls and Measurements, is the corporation established by the family some time ago, and it's been the reason behind a good deal of litigation before Your Honor.
I'm familiar with the case, Mr. Jones.
All right. Your Honor, count one, it's alleged that ICM Controls paid the various attorney's fees. And it thereafter goes on to seek repayment of those fees. But again, the personal representative is named as a petitioner as well. Count two, ICM, the corporation, is alleged to have paid excessive compensation, but again, it's the personal representative that's seeking the action together with ICM. Even though ICM, and this is an attachment to the amended petition, there's a resolution, corporate resolution by ICM that simply references that they are authorizing the personal representative to bring an action on behalf of the shareholders and on behalf of them to recover these monies. The petition, as it alleges, simply says that all of these damages are to the estate. And the problem that we've got is count one is brought by ICM Controls, count two is brought by International Controls and Measurements. Apparently, it's only the personal representative that is seeking the remedy of these surcharges back to benefit the estate against Mr. CADA. So, as alleged, the amended petition simply does not explain or direct our attention to why these independent entities, business entities, are in fact named as petitioners or as indispensable parties. The amended petition specifically states the damages are to the estate. The amended, the corporate resolution specifically says that this damage is allegedly to the beneficiaries of the estate. In our view, it does not adequately support causes of action by ICM Controls for the fees or by ICM, the main corporation, for the excessive compensation. If in fact this is damages to the estate as is alleged, then the personal representative in fact is the entity that should simply be bringing these actions against Mr. Cada as the former administrator ad litem and in his role as a beneficiary. And that's the gist, Your Honor, of our position.
All right, Mr. Fridkin, in reading the motions, et cetera, I find that I am somewhat in agreement with Mr. Jones with regard to the petition being brought on behalf of the two entities. And I'm just wondering what the basis is. It would seem, I mean, I understand the history of this, at least as far as it's been laid out in terms of all the proceedings in the court file. And certainly the personal representative may have a cause of action against Mr. Cada based on his taking money out of estate assets during his tenure as the, I've forgotten what we called him at the time, but
administrator ad litem.
That's it. But you know, so essentially he was in charge of an asset. We could call it cash if we wanted, or an investment account, and he took money out of the investment account, or i.e. the business. But that is a cause of action by the personal representative, and I don't see how she has authorization to file either A, on behalf of these two entities, or B, to file on behalf of these two entities in this cause of action. Maybe she has a cause of action as representative of those two entities up in New York against Mr. Cada, but I don't see that it's in this action. So maybe
may I try to help you see?
Sure. Go ahead.
Good, Your Honor. Let's start with the description of who is an interested person who can participate in these estate proceedings. That's found at Florida Statute Section 731.201, subparagraph 23. And it says any person who may reasonably be expected to be affected by the outcome of the particular proceeding. And it says that the personal representative of the estate shall be deemed to be an interested person. So we start with the fact that the PR is an interested person in essentially everything that's affecting the estate.
I don't have a problem with that.
So then please go to paragraphs 25 through 36. It isn't complicated. It's set forth very clearly that $2.5 million of legal fees were expended by ICM Controls, we allege, for the personal benefit of Andrew to try to undermine the estate's ownership of that asset. So the money, the harm, came out of ICM Control. And the damages, when that $2.5 million, or however much of it we prove was wrongly dispersed, comes back into the treasury of ICM Control where it came. ICM Control then, restates its tax returns and restates all of its collateral harm, if you will, from those funds coming out.
But Mr. Fridkin, that's fine. But again, if you think about this in a more simple way, let's call ICM a stock account. And let's say that Mr. Cada cashed out $2 million of a stock account. So then you have the PR saying, hey, You know, he took money out of the stock account while he was a conservator, and he shouldn't do that. We want the money back. They get the money back. We want to put it back in the stocks. Fine, the PR can do that.
Well,
but again, you don't bring a cause of action on behalf of the stock account.
We do bring the cause of action on behalf of the Treasury from which the funds were taken. They are the correct party to do that. The evidence is going to show
not in the context of this probate action.
And similarly, if you look at the allegations in paragraphs 38 through 42, the allegation is that Mr. Cada paid himself over $5 million without authority from the ICM funds.
Right.
Had those, and so the party that has to recover those funds and again restate taxes because those funds were wrongly distributed out, that's all going to fall on ICM.
Well, then ICM needs to sue Mr. Cada up in New York.
Must come before this estate is that it was this estate, this court, that put Mr. Cada in charge of the funds that he then took out. And it derives from that. Your Honor even recognized at the removal hearing that he should have been paying his costs out of the estate, not out of the corporation. It is the corporation that thus has to come back into this estate and seek a recovery of those funds. It's not complicated. It all sits right here.
But then it's not an action for surcharge. It's a separate cause of action.
Oh, but no, Your Honor, it is absolute. A cause of action for surcharge is a statutory action to recover.
But not on behalf of ICM.
Well, but yes, it is on behalf of ICM because that was the asset that this court prior judge ensconced him into that fiduciary role.
Mm-hmm.
And it is a violation of the fiduciary role that was created by the August 16 or August, I think it's 16, 2016 order appointing him into that role. That's why when he violates the fiduciary duty under that order emanating from this court, the harmed parties, the interested parties who may reasonably be expected to be affected have the right to come in here and surcharge for those violations of fiduciary duty.
All right, Mr. Jones.
Your Honor, for the reasons you've pointed out, it's inappropriate for these third parties to be seeking surcharge.
All right, I'm going to grant your motion. However, I also want it clear that this does not in any way prohibit this is only with regard to the entities, not the personal representative. And this does not prohibit the personal representative, if she's successful in obtaining the cash back, of putting that cash back into the corporations. But nevertheless, I agree with your legal argument in this regards.
So, Your Honor, just so I understand, what you're telling us is you believe the personal representative has the right to bring this action for surcharge, but the two companies should not be parties?
I made my ruling, Mr. Fredkin. So, as I have said, the personal representative has a right to bring this action for surcharge. Absolutely. And if she recovers the money, she can put it back into the entities. But the entities themselves do not have an independent basis for surcharge in this action. They can certainly bring a cause of action against Mr. Cada, but fortunately or unfortunately, that will likely have to occur in New York. So, and it's not going to be a part of this proceeding, which is what I suspect that everybody's trying to avoid. But nevertheless, and I'm not really sure it's necessary, but that's a legal decision that you guys will have to make. So, because I think you can accomplish exactly the same thing if Ms. Cada is successful on her petition for surcharge, obtains the money back, puts the money back in the asset. Again, it'd be the same thing as if he was conservator of a house and he went and got a mortgage and sucked out all the equity in the house. Well, you could get the money back, put the money back in the house. I don't see any difference there, or why we'd be suing on behalf of the house. So again, this is not an appropriate way to go about this problem.
Well, Your Honor,
again, I'm not
please-
going to, Mr. Friedkin, I'm not arguing. That's the basis of my ruling. I'm granting the motion. And again, I want it clear in the order, however, that it does not preclude Ms. Cada, if she's successful on her petition for surcharge, of putting that money back into those entities. If that's what she chooses to do. I'm not sure that's what she would choose to do as representative of the estate. So, all right, so that's it on that hearing. I think that was it. That was all that was scheduled.
Your Honor, may I ask for just clarification of the order?
I thought I was pretty clear, Mr. Jones.
Your Honor, it's just that since it was granted as the entities, but not as to the PR, perhaps I need to direct the question to council whether it will be amended or whether we should answer as to the.
Oh, I got you. Yeah, I'm going to give them 20 days to amend, because I think it's difficult to strike things out and then determine what you need to answer. So
That's exactly my point, Your Honor.
20 days to amend and 20 days to answer.
Thank you, Your Honor.
All right. Thank you, gentlemen.
Thank you, Your Honor. Bye-bye.
Thank you. Okay, Kathy, that's it on the 8:30 docket, and we have a 1:30 docket also.